The imposing marble chamber of the Supreme Court fell into a tense silence as Congresswoman Jasmine Crockett approached the podium. Her striking emerald green suit contrasted sharply with the somber wood paneling, a deliberate choice that signaled her refusal to blend into the background. At 43, the freshman representative from Texas carried herself with the steady confidence of someone who had fought difficult battles in courtrooms across the country before entering politics. Justice Clarence Thomas watched her with visible skepticism from his seat at the far right of the bench. The court's longest-serving member, with over 30 years of experience, had become increasingly vocal during oral arguments in recent terms after decades of famous silence. Court observers had noticed he seemed particularly focused today, reviewing his notes with unusual attention as Crockett arranged her materials. The case, Harrington County NAACP versus Texas Secretary of State, challenged new voting restrictions that plaintiffs claimed systematically suppressed minority votes through limited polling locations, strict ID requirements, and reduced early voting hours. As both a congresswoman and a former civil rights attorney with extensive trial experience, Crockett had been granted the unusual opportunity to argue personally before the nation's highest court. The stakes were enormous. With major elections approaching, the court's ruling would potentially impact voting access for millions of Americans and set precedent for similar laws being considered in states across the country. The tension in the room was palpable as Chief Justice Roberts nodded for Crockett to begin. She had barely completed her opening sentence when Justice Thomas leaned forward, activating his microphone. What followed would begin as one of the most hostile exchanges in recent Supreme Court history, but would end with a response so devastating and unexpected that it would not just stun the courtroom, but break the internet and potentially reshape the national conversation on voting rights for years to come. Before we dive into this incredible confrontation that has everyone talking, take a moment to like this video and subscribe to our channel for more coverage of the most important legal and political showdowns shaping America's future. The morning had begun with the usual formalities of the Supreme Court. The marshal had called the court to order, and the justices had entered in their black robes, taking their seats behind the elevated bench. The audience, consisting of legal scholars, journalists, civil rights leaders, and members of the public fortunate enough to secure a seat, watched attentively as Crockett approached the podium. "Mr. Chief Justice, and may it please the court," Crockett began, her voice clear and measured. "The right to vote is fundamental to our democracy. When that right is systematically burdened, for some citizens more than others based on race, the Constitution and the Voting Rights Act demand judicial intervention." She had barely finished this opening statement when Justice Thomas activated his microphone. "Congresswoman Crockett," he began, emphasizing her political title rather than addressing her as counsel, "you come before this court not just as an attorney, but as an elected official with a particular political agenda. Before we proceed, I'm curious. How can we be confident you're presenting legal arguments rather than simply advancing your partisan objectives?" The question was startling in its directness and personal nature. Thomas wasn't challenging a legal theory or factual claim. He was questioning Crockett's professional integrity and motivations. Several journalists in the press section began scribbling notes furiously at this unusual opening. Crockett maintained her composure. "Justice Thomas, while I do serve in Congress, I'm appearing today in my capacity as an attorney with extensive experience in voting rights litigation. My arguments are grounded in constitutional principles and precedents established by this court." Thomas was unmoved. "Ms. Crockett, your public statements suggest otherwise. You've repeatedly accused state legislatures of intentional racism without evidence. You've called these voting regulations Jim Crow 2.0. Aren't you asking this court to validate your political rhetoric rather than engage in serious constitutional analysis?" His tone had grown more pointed, directly challenging not just her arguments, but her character and professionalism. Several observers noticed Justice Jackson shift uncomfortably in her seat, while Justice Alito appeared to nod slightly in agreement with Thomas's characterization. Crockett's response remained measured. Justice Thomas, the historical context of voting restrictions is directly relevant to this case. Under Arlington Heights, this court established that historical background and sequence of events are proper considerations in determining discriminatory intent. The evidence shows. Thomas interrupted, his voice now carrying an unmistakable edge. Let me be direct, Ms. Crockett. Throughout your career, you've consistently found racism in situations where alternative explanations exist. Now, you're asking this court to see discrimination based on statistical disparities and circumstantial evidence. Isn't your approach fundamentally at odds with this court's precedents requiring clear proof of intentional discrimination? The attack was personal and devastating. Thomas was not merely questioning her legal argument, but suggesting that she routinely manufactured racial grievances for political gain. Several justices appeared visibly uncomfortable. Justice Sotomayor's expression darkened. Chief Justice Roberts looked like he might intervene. The courtroom fell completely silent, all eyes on Crockett. The attack had been unprecedented in its directness and personal nature. Many advocates might have wilted under such pressure, become defensive, or responded with indignation that would have undermined their credibility. What happened next would be replayed millions of times across social media in the days to come. Crockett stood perfectly still, maintaining direct eye contact with Justice Thomas. She took a deliberate breath before speaking, her voice clear and unwavering. Justice Thomas, I appreciate your directness, and I'll respond in kind, she began. You suggest I find discrimination where it doesn't exist. Let me share something personal that shaped my understanding of voting rights. Her voice took on a quality that commanded complete attention. My first job after law school was with the Justice Department's voting section. My first case involved a Texas county that had suddenly moved its only polling place from the center of a black neighborhood to an inaccessible location 15 miles away, with no public transportation. When questioned, officials cited building code issues at the original location. She continued, her intensity building. During discovery, I found emails where those officials discussed how the move would solve our turnout problem in that precinct. When I presented this evidence in court, the judge, a conservative Reagan appointee, called it as clear a case of intentional voter suppression as I've seen in my career. The courtroom remained utterly silent. Crockett was sharing a concrete example that directly countered Thomas's characterization of her as finding discrimination where none existed. That experience taught me something crucial about voting discrimination in modern America, she continued. It rarely announces itself openly. It hides behind seemingly neutral justifications while operating with discriminatory effect and, yes, intent. She reached into her folder and withdrew a document that appeared to be a transcript. Which brings me to something I believe is directly relevant to your concern, Justice Thomas. In your Senate confirmation hearings, you spoke powerfully about your personal experiences with voting discrimination in Georgia. When Senator Biden asked about your approach to voting rights cases, you stated, and I quote, "When analyzing voting regulations, we must sometimes look beyond their facial neutrality to examine their practical operation in specific communities." A murmur rippled through the courtroom. Crockett was using Thomas's own words from his confirmation hearing to counter his attack. You continued, Crockett went on, her voice steady and clear. My grandfather, despite being a tax-paying, law-abiding citizen, faced numerous barriers to voting. Poll taxes, literacy tests, limited hours, all of which were technically applied to everyone, but functioned specifically to prevent black citizens from voting. This taught me that constitutional analysis must sometimes look beyond a law's neutral appearance to its practical effect. The silence in the courtroom deepened, as Thomas's own words about voting discrimination hung in the air. But Crockett wasn't finished. She pulled out another document, what appeared to be a copy of a book. In your memoir, My Grandfather's Son, you wrote even more personally about how seemingly neutral voting restrictions systematically disenfranchised black voters in Georgia. You described how these experiences shaped your understanding of equality under law and the importance of looking beyond surface neutrality. She looked directly at Thomas. Justice Thomas, I don't find discrimination where it doesn't exist. I recognize patterns of discrimination that you yourself have powerfully described from your personal experience. I don't manufacture racial grievances for political gain. I present evidence to courts that directly parallels what you witnessed firsthand growing up in Georgia. Her voice took on a quiet but unmistakable power. The regulations before the court today may differ in form from what your grandfather faced, but the evidence shows they operate with similar effect, creating barriers that disproportionately burden minority voters, implemented immediately after historic minority turnout. As you eloquently wrote in your memoir, sometimes we must look beyond a law's neutral appearance to its practical operation in affected communities. She gestured toward her brief. That's not political rhetoric, Justice Thomas. It's constitutional analysis, grounded in evidence, and in the insights you yourself have shared about recognizing discrimination in its modern forms. The courtroom remained in stunned silence. In a remarkable reversal, Crockett had transformed Thomas's deeply personal attack into the strongest argument for her position. She had used his own words and life experience to counter his characterization of her motivations, while simultaneously highlighting the apparent contradiction between his personal history and his current jurisprudence. Thomas himself appeared momentarily taken aback. After several seconds of silence that felt much longer, he simply said, "Thank you, counsel," and turned off his microphone. The dynamic in the courtroom had completely shifted. Justice Kagan began a new line of questioning about the specific evidence of discriminatory impact. Justice Barrett inquired about the historical patterns of similar voting restrictions. Throughout the remainder of her argument, Crockett responded with composed expertise, citing specific precedents, factual evidence, and constitutional principles. Thomas did not ask another question for the duration of her argument. Those seated near the bench noticed he occasionally glanced down at what appeared to be his confirmation hearing transcript, as if reflecting on the words Crockett had quoted. When Crockett's time expired and she returned to her seat, legal observers in the courtroom exchanged meaningful glances. They had witnessed something extraordinary, a moment when one of the most direct attacks ever launched from the Supreme Court bench had been met with a response so powerful and unexpected that it may have shifted the terms of the constitutional debate itself. The impact of the confrontation between Justice Thomas and Congresswoman Crockett spread rapidly beyond the Supreme Court chamber. As the session concluded and spectators filed out, the hushed whispers in the hallway quickly erupted into animated discussions. Journalists rushed to file their stories. Legal commentators scrambled to analyze the implications, and social media exploded with reactions. By the time Crockett descended the marble steps of the court, news crews were already assembled. Reporters shouted questions about her exchange with Thomas. Maintaining her professionalism, Crockett responded, "Today wasn't about any personal exchange, but about ensuring the court understands the real impact of these voting restrictions on citizens' fundamental rights. Justice Thomas has written powerfully about these issues throughout his career, and I was honored to discuss them with him and the entire court." Her measured response in the face of what many were already describing as an unprecedented attack only enhanced the growing public impression of her as not just a skilled advocate, but someone of extraordinary composure under fire. Within hours, Narjaka Crockett comeback and Narsh Supreme Court Showdown were trending nationwide. Video clips of the exchange, officially released by the court days later, but described in detail by eyewitnesses, spread across social media platforms at lightning speed, accumulating millions of views. Jasmine Crockett just gave a masterclass in how to respond to personal attacks with substance and grace, tweeted one prominent legal commentator, garnering over 300,000 likes within hours. Cable news networks quickly assembled panels of legal experts to discuss the confrontation. On CNN, Jeffrey Toobin called it one of the most extraordinary moments I've witnessed in 30 years covering the Supreme Court. A justice launching a deeply personal attack on an advocate's integrity, followed by that advocate responding not with indignation, but by using the justice's own words and life story to strengthen her case. On MSNBC, the commentary focused on the substantive impact of the exchange. What makes Crockett's response so powerful, noted a legal analyst, is that she didn't respond to the attack with defensiveness or anger. She responded with Thomas's own words about experiencing voting discrimination, creating a moment of profound constitutional reckoning. Even on Fox News, legal commentators acknowledged the effectiveness of Crockett's approach. "Whatever you think of her politics," said one conservative analyst, Congresswoman Crockett showed extraordinary preparation and poise. Rather than taking offense at the questioning, she used it to strengthen her legal argument, exactly what effective advocacy requires. The reaction exploded beyond traditional media. TikTok creators dramatized the exchange, with some videos garnering millions of views. YouTube legal channels posted detailed analyses. Law professors announced they would use the transcript in their advocacy classes. Memes featuring Crockett's key quotes spread across Instagram and Twitter, often paired with captions like, "How to respond to attacks with class," and "Using their own words is the ultimate comeback." "I've never seen a Supreme Court exchange go viral like this," remarked SCOTUS blog founder Tom Goldstein. What makes it so compelling isn't just the drama, but the substantive way Congresswoman Crockett turned a personal attack into a profound constitutional argument. She didn't just defend herself. She used the moment to strengthen her legal position. The White House responded cautiously, with the press secretary stating only that the administration respects the independence of the judiciary and the important role of oral advocacy in our legal system, while avoiding direct comment on the exchange itself. For Thomas, the aftermath appeared uncomfortable. Court watchers noted he was noticeably subdued during the following week's oral arguments. Several sources reported that some justices had expressed private concerns about the tone of his questioning, though these reports remained unconfirmed given the court's tradition of confidentiality. Justice Thomas faces a unique challenge now, observed a former Thomas clerk speaking anonymously to the Washington Post. Congresswoman Crockett didn't just counter his attack. She highlighted an apparent tension between his early expressed views based on personal experience and his current jurisprudence. That's much harder to dismiss than conventional legal arguments. Inside legal academic circles, the discussion went deeper than the immediate confrontation. Constitutional scholars began examining the evolution of Thomas's views on voting rights, comparing his personal reflections and confirmation testimony with his judicial opinions. What makes Crockett's response so effective, wrote Yale law professor Akhil Reed Amar, is that she didn't ask Justice Thomas to abandon his principles, but rather to apply them consistently. By grounding her argument in his own personal history and expressed understanding of discrimination, she created a bridge between lived experience and constitutional interpretation that transcends typical ideological divisions. For Crockett herself, the aftermath brought both intense scrutiny and newfound prominence. Her social media following increased by millions overnight. Interview requests flooded her office. Civil rights organizations celebrated her as a powerful new voice for voting rights. Congresswoman Crockett demonstrated that effective advocacy doesn't require matching aggression with aggression, noted the NAACP Legal Defense Fund in a statement. By responding to personal attack with substantive engagement, with Justice Thomas's own history and words, she elevated the constitutional conversation and reminded us all that the struggle for voting rights transcends partisan divides. The legal community's reaction was particularly significant for its cross-ideological character. A group of over 150 Supreme Court advocates from across the political spectrum signed an open letter praising Crockett's extraordinary preparation, poise under pressure, and ability to transform a challenging moment into an opportunity for substantive constitutional dialogue. Perhaps most remarkably, several former Thomas clerks publicly acknowledged the power of Crockett's approach. By engaging seriously with Justice Thomas's personal history rather than dismissing or attacking him, wrote one in a widely shared opinion piece, Congresswoman Crockett showed respect for his experiences while highlighting how those experiences might inform a different approach to voting rights cases. That's a far more effective advocacy strategy than the typical partisan framing. 2 weeks after the argument, an unexpected development occurred. Justice Thomas, speaking at a judicial conference, made a rare reference to his personal background without directly mentioning Crockett or the case. The experiences that shape us inevitably inform our understanding of the law, he acknowledged. The challenge for judges is determining how those experiences should guide our interpretation of constitutional text and precedent. Legal analysts interpreted this as a potential signal that Crockett's approach had prompted some reflection. The media narrative continued evolving as reporters explored the specific quotes Crockett had cited from Thomas's memoir and confirmation hearings. Several major newspapers published feature articles examining how Thomas's expressed views on voting rights had evolved over his career, some suggesting that his current jurisprudence represented a significant departure from his earlier positions. What we witnessed in that courtroom, wrote a Washington Post columnist, wasn't just a dramatic personal exchange. It was a moment when one of the court's most conservative justices was confronted not with abstract legal theories, but with his own words about the lived reality of voting discrimination. A confrontation that may have opened space for a more nuanced conversation about how the Constitution protects political participation. The impact extended far beyond this single case. Attorneys challenging similar voting restrictions in other states began incorporating references to Thomas's confirmation testimony and memoir in their briefs, adopting Crockett's approach of engaging with the justices' expressed principles and experiences rather than simply opposing their conclusions. 6 weeks after the oral argument, the Supreme Court announced it would issue its ruling in Harrington County, NAACP versus Texas, Secretary of State, the following Monday. Legal experts remained divided on the likely outcome, though many noted that Thomas's uncharacteristic silence following Crockett's response suggested the possibility of at least some reconsideration of his approach. Whatever the specific result in this case, observed Harvard Law professor Lawrence Tribe, Congresswoman Crockett has demonstrated a powerful approach to constitutional advocacy, taking justices' expressed principles and personal experiences seriously and asking them to apply those insights consistently, even when doing so might lead to results different from their typical pattern. That approach may influence constitutional dialogue for years to come. For Crockett herself, who had begun her career representing clients who often felt voiceless against powerful institutions, the opportunity to reshape the national conversation about voting rights at the highest level represented a profound fulfillment of her commitment to equal justice. As she told a group of law students at Howard University the week before the ruling, the Constitution's promises of equality and participation belong to all Americans. By taking seriously the insights of those who have experienced discrimination firsthand, including those who now sit in positions of judicial authority, we strengthen the case for fulfilling those promises today. When the court's decision was finally announced, legal observers noted something remarkable. While the court didn't fully accept Crockett's position, the majority opinion, written by Chief Justice Roberts, struck down several key provisions of the Texas law, finding they imposed disproportionate burdens without adequate justification. Most surprisingly to court watchers, Justice Thomas didn't write a full dissent as many had expected. Instead, he concurred in part and dissented in part, acknowledging that facially neutral voting restrictions that operate with particular harshness against minority communities require careful scrutiny to ensure they serve legitimate state interests rather than impermissible purposes. The opinion included a paragraph referencing the historical context of voting restrictions that appeared neutral but functioned to exclude minority voters, a clear echo of the argument Crockett had developed using Thomas's own personal history. For voting rights advocates, while the decision wasn't a complete victory, it represented a significant shift from the court's recent trajectory of limiting voting rights protections. Legal analysts immediately began assessing whether Thomas's partial concurrence signaled a potential reconsideration of his approach to these cases. What began as a personal attack ended with Thomas at least partially reconsidering his position, noted a CNN legal analyst. It's a powerful reminder that effective advocacy isn't just about legal doctrine, but about making human connections. In this case, reconnecting a justice with his own expressed understanding of discrimination's reality. The confrontation between Justice Thomas and Congresswoman Crockett had transcended a mere viral moment to become something far more significant. A case study in how preparation, poise, and the strategic use of personal narrative could potentially shift the terms of constitutional debate. By transforming what began as a personal attack into an opportunity to strengthen her case, Crockett had demonstrated an approach to advocacy that might help bridge some of the deep divides in American constitutional discourse. As legal scholars and advocates studied the opinions and planned their strategies for future cases, one thing became clear: the exchange between Justice Thomas and Congresswoman Crockett would be remembered not just for its dramatic confrontation, but for its substantive contribution to how we think about the Constitution's protection of voting rights. A protection that, as Thomas's own life story had powerfully illustrated, must sometimes look beyond the face of the law to its operation in practice. Thanks for watching our coverage of this historic Supreme Court confrontation between Justice Clarence Thomas and Congresswoman Jasmine Crockett. If you found this analysis eye-opening, please hit that like button and subscribe to our channel for more in-depth coverage of the crucial legal and political debates shaping our democracy. Comment below with your thoughts on effective advocacy strategies for protecting fundamental rights.